I am Dr. Kabir Ahmed, Associate Professor, University School of Law and Research, USTM Meghalaya. Today, I am here to give a brief lecture on principles of criminal liability. So, in this topic, I shall try to give a broad outline of the principles which regulate the criminal justice administration system in India. So prior to that, I shall give a brief introduction. We know that crime is a threat to the society and is a challenge to the government. Therefore, it is the responsibility of the state to do needful to punish offenders and restore order, peace and tranquility in the society. State therefore takes steps to ensure that offenders face trial and get their due punishment. So the state becomes a party in a criminal case and prosecutes the accused person. And in this process, the public prosecutor represents the state and tries to ensure fair prosecution of the accused person. So such kind of activity on the part of the state have to run under some basic postulates of criminal justice administration. These basic postulates of criminal justice administration requires that procedural law for administration of criminal justice must ensure, number one, adherence to the relevant constitutional protections. Two, adherence to the principles of natural justice. And three, adherence to other principles of criminal justice administration. So these three sets of principles regulates the total justice administration system, and the criminal justice administration system has to adhere to these three sets of principles. So we shall discuss one after another. The first one is constitutional protections and criminal liability. Article 20 of the Constitution of India provides protection against conviction. And if we go through the article of section 20, we will find that this article provides three types of protection. The first protection is ex post facto law, that no retrospective criminalization can be made. So, in this process, it is the gist of this protection that if an activity is to be regarded as a crime, and for such activity, if a person is to be tried, then there must be some law which must prescribe such an activity as a crime. Without such prescription, no activity can be regarded as crime and no punishment can be given. That's why this protection extends to a bit further, that if an activity is not a crime today, by laying down a subsequent law, such an activity cannot be made punishable. That such kind of law will be prospective in operation, that cannot be retrospectively operated. In the same way, if a certain punishment is prescribed, then for an already committed act, such punishment cannot be enhanced. Whatever is the punishment and whatever is the crime prescribed for a particular activity, that has to be taken into consideration, and no retrospective legislation in this regard cannot be made to make an act punishable or to provide a larger punishment. The second protection under this Article 20 of the Constitution of India is double jeopardy. Double jeopardy refers to a protection where no person can be punished twice for the same offense. So this protection provides that if a case is already decided against a person, then for such offense, a fresh case cannot be brought before the court. And such kind of protection provides accused person protection against repeated jeopardy. So, third protection which is provided under Article 20 is provided by protection against self-incrimination. The implication of this protection is that accused cannot be forced to give witness against himself or themselves. That's why no procedure of law can compel a person to give testimony against him. And that's why these protections under Article 20 protects a socially weaker person in contrast to the power and might of the state to restore their personal liberty and protect themselves from against the force of state. The next protection is the most popular protection provided under Article 21 of the Constitution, which guarantees a right to life and personal liberty. The wording of Article 21 states that no person can be deprived of his life and personal liberty except according to a procedure established by law. That's why if arrest is made, that in context of this bare provision, we have to examine the effect of arrest and detention. So we know that arrest or imprisonment affects an individual's right to life and personal liberty. So personal liberty is threatened by detention or imprisonment. And that's why if a person is to be arrested or detained in custody, that arrest and detention should be as per a process established by law. That is, without due process of law, such an arrest or detention cannot be made. That's why this due process gives a guarantee that if a person's personal right and liberty so this article gives protection that if a person's personal liberty is seized, then it has to be as per the mandate of Article 21. And for that purpose, there should be an established process of law without which a person's personal right and liberty cannot be curtailed. The third protection provided under this Constitution is Article 22. It gives protection against arrest and detention in certain cases. So if we go through the bare provisions of this Article 22, we shall find that there exists a right of information in favor of the arrested person of the grounds of arrest. And prior to detention, and if such arrested person is to be detained, then such detained person shall be produced before the nearest magistrate within 24 hours. These two protections, these two rights, which gives guarantee of a person's personal liberty in case of, gives protection against arrest and detention. So these are basic structure, constitutional guarantee given as a fundamental right to a person. And that's why this cannot be curtailed, and it provides the backbone of a person's innocence. Or if a person is to be tried as an accused person for a crime, that these protections have to be ensured by the state machinery. So after this constitutional protection, another very important protection is provided by way of the adherence to the principle of natural justice. So if the principle of natural justice is adhered, then we can give assurance that fairness in this procedure of trial has been adopted. So this principle of natural justice has two main principles, and these principles are regarded as fundamental so far as we consider the process or procedural fairness of a criminal trial. So first principle is rule against biasness. The Latin maxim which supports such kind of rule is nemo debet or nemo judex in propria causa, that no man can be judge in his own case. So equivalent to this maxim, a principle in English has been developed which is known as rule against biasness. The gist of this rule is that if a person is related to the subject matter of a particular suit in any of the recognized way, that means if he has some connection with the subject matter of the suit or he has some interest with the subject matter of the suit, if the litigant party or one of the litigant party is in some way related to him, if he has some pecuniary interest in the subject matter of the suit, that means in this way many types of relations have been regarded, that if a judge stands in such a relationship with in a particular case, then there exists a possibility of biasness. And in such situation, it is the demand of the principle of natural justice that such person should not act as a judge in deciding a particular case. So this is rule against biasness. In the history of judicial pronouncement, we have found that around 6 types of biasness have been recognized, and these biasnesses are academically labeled as subject matter biasness, pecuniary biasness, relative biasness, and biasness due to obstinacy, ideological biasness in this way. So these types of biasness vitiates the whole process and this biasness are not only to be checked whether they are really existent in a particular case, because the principle of natural justice demands that justice should not only be done, but at the same time it should be seem to be done. That's why the procedure or the process of justice administration should be free from such kind of possibility. And to remove such kind of possibility, if there exists such a relationship, whether such biasness has actually occurred or not is not a question. Just mere existence of such relationship from the side of with the subject matter of a suit and of the judge will vitiate the process. The second important principle of natural justice is rule of fair hearing. That means nemo judex in propria causa in Latin form. No, that means no odi alteram pardem. Rule of fair hearing, that means odi alteram pardem. So the implication of this principle is that no adverse decision should be passed against a party without giving him a fair chance of defense. So it is the principle of criminal justice administration system that if a decision is being taken against a person, then such decision, before taking such a decision, the party against whom such a decision is being taken, he should be given a fair chance of his defense. He should be given reasonable opportunity to produce before the court all the defenses which he has in his hand, and that opportunity should be a reasonable opportunity. And in the course of time, around 13 rights have been recognized under this principle, starting from right to notice, right to notice, and that means we have 13 types of rights protected under this head. And therefore, with the adherence of the principle of natural justice, we can ensure that fairness in the criminal justice administration system is ensured. The third bundle of principles which are important for the administration of criminal justice and under the influence of which the justice administration system in India is governed are a number of some important principles, are some principles which are regarded as essential for administration of criminal justice. These principles are: number one, presumption of innocence. And this principle refers to an idea that the accused is innocent until proven guilty beyond reasonable doubt. So if a person is proved guilty, if a person is an accused, then to regard him as a criminal, his guilt should be proved beyond reasonable doubt. If there exists a reasonable doubt, that it will be tilted in favor of the accused person. So it is the duty of the prosecution side to prove the guilt of the accused person beyond all reasonable doubt. And it is therefore a very potent protection in favor of the accused person. Second protection is strict interpretation of criminal law. That means where there is a criminal legislation which imposes some criminal liability or imposes some penalty on a person, those provisions of law should be strictly interpreted. Broad interpretation cannot be given. And this is the established principle of interpretation of law with regard to criminal liability. The strict interpretation works in two ways. First one is that the provisions of law which defines an activity as crime should be strictly interpreted in relation to all the conditions laid down in that definition of that particular act. Strictly. That means all the necessary elements which constitutes a particular crime have to be satisfied. Otherwise, such an activity will not be regarded as a crime. If even a single essential element is missing, then the accused person will be regarded as not guilty. So that's why in interpreting the bare provisions of the law which defines an activity as guilt, it should be very strictly interpreted. And second principle is that where there ambiguity lies in the provisions of a penal statute, that ambiguity should be very strictly interpreted so that no expansion of meaning should be given to encompass an activity within the definition of crime. And that's why strict interpretation is the second protection which is exercised by the Court of Criminal Justice, and such kind of strict interpretation, principle of strict interpretation, also works in favor of the accused person. And we know that in recent days our judicial system is influenced by humanitarian jurisprudence, and under the influence of humanitarian jurisprudence we want to keep the face of our judicial system humane, and that's why fair treatment to the accused person is the demand of the humanitarian jurisprudence. So an accused person should not be as a criminal until his guilt is proved beyond doubt, and that's why fair treatment is the requirement which is under the influence of humanitarian jurisprudence. And the last protection which is given is doctrine of onus probendi, that is burden of proof. In criminal justice administration system, the burden of proving the guilt of the accused person lies on the prosecution side. It is not the duty of the accused person to prove his innocence. Rather, it is the duty of the prosecution side to bring in front of the court all the evidences which can prove the guilt of the accused person beyond any reasonable doubt. So this burden of proof gives an immunity to the accused person that he need not prove his innocence. But this does not mean that he cannot give any evidence or any proof of his innocence. He is also entitled to give any evidence or proof whenever he wants. That means at the appropriate time when he wants to produce such proof of innocence. But primarily responsibility lies on the prosecution side to prove the guilt of the accused person beyond reasonable doubt by producing all the evidence which the prosecution side has in their possession against the accused person. So under the aegis of these three types of principles, the criminal justice administration system is delivered in India. The Indian judicial system has laid down or is founded on some humane and very civilized principle of justice administration. But everything is not fair, everything is not good here. That's why Indian judicial system has been facing potential challenges in the way of its criminal justice administration. And one of those challenges are delay in justice delivery. It is estimated that over 4.4 crores of cases pending in Indian courts till 2024. So, moreover, under trials are languishing in jails for years, waiting for a fair trial. Besides that, police accountability and excessive force are rampant. Police are resorting to some political influence, or influential people are trying to influence the whole trial process. In this way, we have these challenges also. Moreover, weak enforcement of police accountability laws have enhanced this challenge, degree of this challenge, and we have case law in this regard, Prakashing versus Union of India 2006, which ordered for police reform. That's why police accountability and use of excessive force is very rampant, and it acts against the weaker, socially and economically weaker sections of the society. Another challenge is corruption in the criminal justice system. Bribery in investigations and trials affect justice. Manipulated justice in high-profile cases are very rampant. So these are the potential challenges, and unless these challenges are removed and properly addressed, then we will not have a very laudable criminal justice administration system in India. So to remove those challenges, we can bring some measures, and speedy trial and judicial reforms may be one of them. And in this order, we may establish fast-track courts for serious crimes to be decided expeditiously, and technology-driven justice, that is e-courts, online case tracking, etc., may be adopted to remove time requirements. Second remedy which we may, or measures which we may adopt, is police reforms and accountability, strengthening oversight committees and mandatory body cameras for police officers so as to track their activity and to have the record of their activity and behavior with the alleged people or with the persons having weak social standing. Tracking corruption and delays may be another measure. Strict implementation of anti-corruption laws, greater judicial transparency in cases of assignments, etc., may be a very potent instrument, because judicial corruptions are also reported nowadays. And another measure which we may take is strengthening investigation and forensic capabilities. Investments in modern forensic labs and expert training may, to a great extent, help in this process of strengthening the criminal justice administration system. DNA and fingerprint evidences to strengthen cases can also be adopted to strengthen the documentary and evidence process in a criminal trial. In this way, we can improve our criminal justice administration system. So in conclusion, we may say that criminal liability of a person in India is fixed against constitutional safeguards, procedural fairness, and the principle of natural justice, besides strict interpretation of the defined liability under the particular law in a very precise manner. The adherence to those principles are the yardstick through which degree of civility in justice administration is measured in the world. That how far these principles of fairness, these principles for the protection of the accused person's personal liberty are adhered to in the administration of criminal justice is regarded as the yardstick through which the status of civilization is measured, or standard of justice administration system is measured throughout the world. And to keep the humane face of our justice administration, we prefer 9 criminals to go free than to punish an innocent person. And that's why we may regard that the face of Indian criminal justice administration system is very humane, and we can assume that no innocent person is hereby regarded as guilty, in spite of the fact that we have many shortcomings in our criminal justice administration system for which some innocent persons are suffering. Some are suffering as an under trial prisoner, and some are languishing in jail as under trial, and while some others are waiting for justice or wasting their valuable time of life in criminal trial process. So we hope that if those measures are adopted and proper measures are taken, then we can remove the difficulty which we have in the process of our criminal justice administration system. Thank you all.